Hello everyone, I hope you all are having a wonderful day today. Thank you for joining with me on this session to discuss a very important topic in the subject of conflicts of law, or otherwise known as private international law. Today we will be discussing the topic of domicile. But before we go straight into the topic discussion, let me preface this video with my perspective on the subject of conflicts of law as well. It's mainly a case law driven subject as opposed to a statute driven subject like criminal law or even constitutional law. So there's not a whole lot of statutory provisions for you to remember, but there are definitely some interesting case laws. And once you have grabbed the main concepts and gone through the case laws, you will definitely see that this is a very easy subject to score higher marks in. And if you put a little bit of effort into it, you will definitely see that. So now that you all have been properly motivated, let's get on with our topic, which is domicile. So you may have come across this word in Thesavalame law before, but I will give you a little introduction on the word as well. In simple terms, domicile means a permanent home and a link between a person and a place. In law, however, domicile is the status or attribution of being a lawful permanent resident in a particular jurisdiction. For example, I am a lawful permanent resident in Sri Lanka, therefore my domicile is also going to be Sri Lanka. A person can remain domiciled in a jurisdiction even after he has left it if he has maintained sufficient links with that jurisdiction or has not displayed an intention to leave permanently. This will be further illustrated in the latter part of the session. For now, we will have a look at the difference between nationality and domicile. Although very similar at first glance, nationality should not be confused with domicile. Domicile is based on the concept of individual liberty. An individual is free to establish his domicile at any place in the world, and national boundary is not a hindrance in the choice of domicile. That means a person may have nationality of one country and domicile in another. For example, once again, my nationality is with Sri Lanka, but I am completely free to establish a domicile of my choice in any other country in the world. But in the earlier days, however, the courts favored nationality over domicile in their judgments. But this ultimately led to some disparities between lex parte, or the law of nationality, and lex domicile, or the law of domicile. This ultimately led the courts to lean heavily on lex domicile and keep the law of the nationality in the back burner as a last resort. The case of Ray Samara and the case of O'Keefe are going to be the prime examples that can be given in this situation. Let's have a look at the Ray Samara case. Samara was a rich Tunisian Jew who died domiciled in Italy, Livorno. He left Tunisia and settled in Paris. Then further he went to settle in Livorno, Italy as well. While he was in Paris, he made a will which was valid in French law but not valid in Jewish law, the law of his nationality. The relatives of Samara, after his death, challenged the validity of the will in the Italian court, on the ground that Samara died with the nationality of a Tunisian. Therefore, the law of nationality should govern the succession to his property. The defendant, on the other hand, contended that nationality of Samara was lost as he left Tunisia, and as Samara had no nationality at the time of death, he should be governed by the lex domicile. The decision was first given on favor of the defendant, but was later overturned on the ground of lack of proof of the loss of nationality. In the case of O'Keefe, an English woman, O'Keefe died intestate in Italy. Her domicile of origin was actually Ayr. Since English law applied the foreign court theory, it proceeded to decide the matter as the Italian court would decide it. On this matter, the Italian court applies the law of nationality, which would be the British law in this case. But since there is no British private international law relating to succession, the court applied the law of the Ayr, the law of her domicile of origin. The rationale was that she had never lost her British nationality, though she had acquired a domicile of choice in Italy. However, you can see that in these judgments, the concept of individual liberty was largely overlooked or undermined. So therefore, with the progression of the time, the courts actually acknowledged it and started giving prominence to the domicile law. In summary, domicile is a jural concept used for the purpose of establishing a connection of a person with the law of a domicile country, And domicile is based on the concept of individual liberty. An individual is free to establish his domicile at any place in the world. National boundary is not going to be a hindrance in the choice of this domicile. That means a person may have nationality of one country and domicile in another. In the light of these cases, we should also look into the importance of domicile when it comes to personal or private matters. In personal matters, lex parte or the law of the nationality is the governing law in civil law countries, and the lex domicile or the law of the domicile country is the governing law in the common law countries. In common law countries, an individual's domicile is utilized as a connecting factor to establish lex causa. In many areas of law, especially in matters connected with person's personal life, such as marriage, adoption, succession, and etc. Hence, more often than not, the result of a suit depends on the fact as in which country the suit has been filed. Therefore, properly determining the domicile of involved parties is a vital part of the case. Now, let's look into the three main principles of domicile as well. The first main principle is that no one can live without a domicile. The bottom line is, if a person has been born, he or she must have a domicile. In the second principle, it says that no one can have more than one domicile at the same time. However, there are some statutory exceptions for this, especially in federal governments. A person can have a federal domicile and a separate regional domicile for the purpose of law. And the third main point is going to be, the third main principle actually is going to be that the burden of proof is on the one who asserts to change of domicile. So, for example, to illustrate this, let's say you are having a divorce case with your spouse, and in court your spouse is going to say that this case cannot be heard under Sri Lankan law because you are actually a domicile of India. So the applicable law should be the Indian law. So in that case, your spouse has challenged the domicile that you chose, that you are claiming to be. So in this case, the burden of proof entirely falls on your spouse to prove that you are actually not a domicile of Sri Lanka, that you are a domicile of India, to the courts in this case. Alright, so when it comes to types of domiciles, domicile can be categorized into three different categories. They can be domicile of origin, domicile of choice, and domicile of dependence. The first one is going to be domicile of origin. The domicile of origin is the one that law confers on every person upon birth. So it ties into the main principle that we talked about before, that no person cannot be without a domicile. So every one of us are going to have a domicile of origin at the point of birth. So it continues to exist, this domicile of origin continues to exist so long as you does not acquire another domicile. Even if a person does give up his domicile of origin, it will continue to exist as long as he does not acquire a new domicile. The moment the person gives up his domicile of choice, his domicile of origin will revive. The baseline is that if a person is born, he or she must have a domicile. So therefore, your domicile of origin it can be said that your domicile of origin is never lost but undermined by the domicile of choice. Next up, we have domicile of choice. Domicile of choice is the one any independent person can acquire. Whether a person has capacity to acquire domicile of choice is actually determined by the law of his existing domicile. For example, I'll take me again. So I am a domicile of Sri Lanka currently. So I'm going to go ahead and make a domicile of choice and I'm going to choose UK. So if I have the capacity to acquire my UK as my domicile of choice, it will be actually governed by the laws of Sri Lanka. So if I want to acquire domicile in India, my capacity will depend on Sri Lankan law. Same goes for any other country as like that. And for the acquisition of a domicile of choice, the following conditions must be satisfied by an individual. So a person must be at least 16 years of age or above, and the existence of factum and animus must be confirmed. right? So you might be wondering what is factum and what is animus. So animus is the intention to reside in a place permanently or for an indefinite period of time. And factum is the fact or the having of actual residence in the country the person wishes to establish their domicile. So animus has to be coupled with factum for the eligible person to acquire domicile of choice. The importance of animus or the intention to reside has been given priority in many landmark judgments. For example, we can take the judgments of Vinas versus AG, Ramsey versus Liverpool Royal Infirmary. So let's have a look at the case of Vinas versus AG. So Vinas was an American millionaire who hated England but spent 37 years of his life there. However, he was there for medical care, and he actually built a fleet of ships to fly USA flag idea to dominate the shipping world over there and above England. He had dreams of returning to USA and controlling the fleet from a dock in Maryland. It was held that after his death that he believed he would return to USA, but that belief he had that he will someday return to USA actually prevented him from acquiring domicile in England, despite the fact he lived there for 37 years. And in the case of Ramsey versus Liverpool Royal Infirmary, a person, Mr. Ramsey, died leaving behind a will which was formally valid under Scottish law. Scotland was his domicile of origin actually. Although invalid by the law of England, although this will he created was invalid by the law of England. From 1892 till his death in 1927, he lived in Liverpool, England for 17 years. So during these 17 years, he never actually went to Scotland. The only fact that still connected him with his domicile of origin, Scotland, was that he often said that he was very proud to be a Glasgow man. The House of Lords in this case actually unanimously held that it was not proved that he made Liverpool or England his permanent home, and therefore he continued to have his Scottish domicile of origin. Another case that has prominence is going to be the case of Bell versus Kennedy. So Bell was a Jamaican gentleman. Bell had a Jamaican domicile of origin, but after leaving Jamaica, he was uncertain to make a decision as to whether he should settle in Scotland or England. Therefore, in his case, the House of Lords actually held that he had not lost his Jamaican domicile of origin. So you can see in here, in all three cases, the animus has been given priority in here. The courts have looked at the fact that all these three people in these three different cases had their hearts set in a different country, although they had lived in a different one for a particularly long time. So, like I mentioned before, animus is, or the intention is going to play a major part in these when acquiring a domicile of choice. Alright, so for the domicile of dependence, married women, children, or minors and mentally disordered persons such as idiots and lunatics fall into the category of dependence. Let's have a look at married women first. Married women acquire the domicile of husband and at the point of marriage, and if husband changes his domicile, hers will change as well, irrespective of her intentions and irrespective of whether she lives with him still. The same thing will apply if the husband and wife have judicially separated, but it doesn't when divorce has taken place. So if husband and wife have judicially separated, her domicile will still change with the husband's, but the husband and wife has divorced already, then the wife will have her own individual domicile. When it comes to children, legitimate children will have their father's domicile and illegitimate children will have their mother's domicile. Adopted children are actually considered as legitimate children under law, so hence they will have the father's domicile like a legitimate child would have. In the case of orphans, illegitimate children without a mother, and then the domicile of the child will remain at the time of the parent's death. So if illegitimate child's mother mother dies while she was domiciled in Sri Lanka, then the illegitimate child's, or in this case the orphan's, domicile will remain as Sri Lanka. And the fact that the guardian's domicile changes does not affect the child's domicile in this case either. Alright, and for the mentally incapable people, also an independent person who becomes insane cannot change his domicile, as he is incapable of exercising any free will of his, even if even his guardians cannot actually change his domicile. Therefore, these mentally incapable people or lunatics will retain their domicile which he had when he became a lunatic, even if he goes to another country and settles there. So, if person A is a lunatic, and at the time of he became a lunatic, if his domicile was Sri Lanka, his domicile will continue to be Sri Lanka, even if his guardian changes the domicile to UK and takes the lunatic or person A with him to UK. The lunatic's domicile will still remain as Sri Lanka. And there are some special cases when considering domicile that we should definitely look into. So the number one would be prisoners. So if a person is punished with the exiled for life punishment, they will actually acquire domicile in prison. And if the prisoner's imprisonment is a temporary one, then their earlier domicile will be retained at the time of their release. When it comes to soldiers, the domicile of soldiers will largely depend on the circumstances of war. And finally, when it comes to refugees, if a refugee intends to return to their homeland when it becomes safe for them, then their domicile is going to be considered as the homeland. And if a refugee changes his mind and decides to stay in the country that they sought refuge in, then their domicile is going to be the country they sought refuge in. Alright. On the final point of when it comes to domicile, we have the abandonment of domicile of choice. A person can actually abandon their domicile of choice by ceasing to be residing there, and also by ceasing the intention to reside there permanently or indefinitely. However, if there's an intention to return, or he has decided to leave but hasn't left, then the domicile of choice will not be considered as abandoned. The primary case we will be looking at in the abandonment of domicile of choice is going to be the case of Goods of Raffanel's case. The person in here, Madame Raffanel, the widow of a French naval officer, had her domicile of origin in England. She had her domicile of choice in France, and she embarked on a cruise ship to leave France for good. But however, when she was about to get on the ship, she had fallen ill and she could not leave France at the time of her death. So when she died, she was still stuck on France. Therefore, even though she had the intention to leave France for good, since she died in France still, the court held that she died domiciled in France, or her domicile at the time of death was her domicile of choice. Alright, so with all that we have discussed so far in mind, let's see how we can use them practically in an exam question as well. Today I have chosen the question number 5 of the 2020 October paper, which is an issue spotting question that carries 15 marks, and you will actually see why I emphasized on the importance of case law in the session so far. So the question goes like this. Ramsley married Stella, who had a Swiss domicile, and he died leaving behind a will which was formally valid under Scottish law, though invalid by Swiss law. The testator was born in Glasgow in 1845 and thus had a Scottish domicile of origin. From 1892 till his death in 1927, he lived in Geneva, Switzerland. During these 35 years, he had never went to Scotland. The only fact that still connected him with Scotland was that he often said that he was very proud he was very proud to be a Glasgow man. He even did not go to attend the funeral of his mother in Glasgow. So you have to advise Stella, who is contending her two sons, where they claim that Swiss law applies in the case of, in regards to Ramsay's will over here. You can see that the issue is clearly about succession. More specifically, it's about the domicile of the deceased person, Ramsay, and the validity of his last will, depending on the domicile law. If you have studied the case laws carefully, by now you must be able to find that the case law that they have taken in here has been mentioned before. By now you must be able to find the case law that has had the almost identical issue to this question over here. It's the case of Ramsley versus Liverpool Royal Infirmary. Actually, the facts in both the cases, both the case and our question is exactly the same, almost word for word. So if you knew the case law and remembered it, you would have no problem on scoring all 15 marks that are allocated to this question over here. So when it comes to the actual answer, what you can do is go with a brief introduction of the facts of the issue in the question and then move on to make inferences from the judgment that has already been established, and you can point out that similarities of the facts and the rationale taken by the House of the Lords in Liverpool Infirmary case when building your answer. And giving your advice to Stella here, in Liverpool case, actually it was the unanimous opinion of the House of the Lords that Ramsay didn't hold domicile in England despite living there for years and years, and you can build your answer from that point onward on how the courts might decide the judgment on the current issue you have been given in the question. Alright, to summarize what we have done and gone through in this session so far, today we talked in detail about the topic of domicile. More specifically, we gave a brief introduction onto the word domicile. We talked about how domicile gained prominence over nationality over time, the main principles of domicile, the different types of domiciles and the special cases that decides the domicile of a person, and the abandonment of a person's domicile of choice. We also had a brief look into a issue spotting past paper question as well. So I hope you all got something useful out of this session. We will definitely meet again with a discussion on different topic in the subject of conflicts of law. Until then, I wish you all the best of luck with your studies. Thank you.